Can a magistrate exercise his power in contempt proceedings of his own court? The judiciary's authority rests on its ability to enforce its orders and maintain its dignity. When someone disobeys or undermines a court's directive, contempt of court proceedings come into play. But can a magistrate, presiding over a lower court, take action against contempt of their own court? This question touches on the balance of judicial power and the mechanisms to protect the administration of justice. In this video, we explore the contempt powers of courts in India, focusing on whether magistrates can initiate contempt proceedings, with insights from the Contempt of Courts Act, 1971 and a key judgment, Ahmednagar Municipal Council versus Suresh Shankar Gangad, 2002. In India, the Supreme Court and High Courts have inherent powers to punish for contempt, derived from the Constitution and the Contempt of Courts Act, 1971. These powers ensure their orders are respected and the judicial process remains untainted. So, under Article 129 of the Constitution, the Supreme Court is recognized as a court of record with the authority to punish for contempt of itself. This includes both civil contempt, which is basically disobeying court orders, and criminal contempt, which covers acts that scandalize or obstruct justice. Now, Article 215 grants high courts similar powers as courts of record, allowing them to punish contempt of themselves. Plus, Section 10 of the Contempt of Courts Act, 1971, also empowers high courts to punish contempt of subordinate courts, which really ensures oversight over lower judicial bodies. The Contempt of Courts Act, 1971, lays out some key definitions. Section 2(b) defines civil contempt as willful disobedience to a court's judgment, order, or process. And Section 2(c) defines criminal contempt as acts that scandalize or lower the court's authority, prejudice judicial proceedings, or obstruct the administration of justice. Section 12 allows punishment for contempt, including up to 6 months imprisonment, a fine of 2,000 rupees or both, with provisions for accepting genuine apologies. These provisions equip apex and high courts to act swiftly against contempt. But what about magistrates in subordinate courts? Criminal contempt, as per Section 2(c), includes actions like publishing material that undermines a court's authority or obstructing justice. For subordinate courts, Section 15(2) of the Contempt of Courts Act, 1971, is critical. It states, in the case of any criminal contempt of a subordinate court, the High Court may take action on a reference made to it by the subordinate court or on a motion made by the Advocate General, under Section 15(2). So, the Bombay High Court's judgment in Ahmednagar Municipal Council versus Suresh Shankar Gangad actually clarifies a magistrate's role in contempt proceedings. Here are the facts. The Ahmednagar Municipal Council revised the annual rental value of the respondent's property, which was reduced to 2,700 rupees by a sessions court back in 1994. But ignoring this, the council still issued a tax notice in 1995 based on a higher annual rental value, and that's what led the respondent to allege criminal contempt. Now, coming to the ruling, the Bombay High Court upheld the Chief Judicial Magistrate's authority, stating that any subordinate court against which criminal contempt is committed can refer the matter to the High Court. The significance here is pretty clear. The judgment confirms that magistrates, as heads of subordinate courts, can actually initiate contempt references when their court's orders are violated, which really reinforces their role in protecting judicial authority. Magistrates, presiding over subordinate courts like those of chief judicial magistrates or judicial magistrates, do not have the inherent power to punish for contempt like the Supreme Court or High Courts. However, they can exercise contempt-related authority through the following mechanisms. Identifying contempt. A magistrate can recognize acts of contempt in their court. Referring criminal contempt under Section 15(2). If a magistrate believes criminal contempt has occurred, they can document the act, for example, non-compliance or interference, and make a reasoned reference to the High Court. The reference should detail the contemptuous conduct, as seen in the Ahmednagar case, where the Chief Judicial Magistrate noted the Municipal Council's disregard for a court-ordered ARV. Magistrates play a vital role in upholding judicial authority by addressing contempt in their courts, primarily through Section 15, 2 references for criminal contempt. For more such legal insights share and subscribe to Justice Lens.